Okay, so you have learned about industrial design as an important forms of IP. Okay, so now and already I referred that in respect of IP, the different components involved. Although this class I will deal in different part, but why not to say repeat or remind you different elements of any statute of IP. Just like say again I am repeating the same thing, just creation of right, let us say put it over CR, creation of right, then transaction or transfer of right, yes, so of right, and that enforcement of right, ER, enforcement of right. Okay. So in this case also industrial design similarly, or everything is applicable to you. So I have discussed about creation of rights part. So similarly, that you can license your industrial design, you can sell your industrial design, there is no problem. After creation of rights, you can transact or transfer the rights by virtue of sale, license, sale, license, assignment. All those things also can be applicable for your industrial designs also. There is no problem. You can apply that things also. You can the transaction routes also can be applicable for this also. Okay. So just like a assignment will be applicable. Then enforcement, just like after creation of right, you can enforce it. I already told you the beauty of intellectual property rights. You yourself can use and get the money by transaction route. You can get the money by enforcement route. So somebody infringes your industrial design, you will get money out of that. So that is called enforcement. That the damages, you can get damages out of that infringement work. So that is also some source of return. Return, you are getting some return. Okay, return by means of transaction, return by transaction use. So a very interesting thing. Return, you yourself using, you are getting return. You are licensing somebody, license, you are getting return. You are filing an infringement suit, you are getting a return. Infringement, damage. Let's say damage, okay, damage, okay. So all these things are giving you a return. Okay, this part you should remember. Okay, so here another two part before going to this class specifically, I want to inform you. Just like say there is a clause, two specific clauses there in the Act. Just like one is related to exhibitions. If you exhibit your article, this is what you should remember. Just like some cases, you see that sometimes government is attack some government or private entity. They are organizing some exhibitions to exhibit product or product design specifically. That is although that applicable for technical features, but product design features also sometimes some company ask for competition or exhibitions. So if you exhibit that things, automatically you are understanding this will be considered as a publication before filing date. If you exhibit, this will be considered prior publications. So that may destroy the novelty of your industrial design. So for that reason, there is a clause that if you somebody apply for industrial design registrations, and if that things, if that industrial design things, you understand that industrial design thing that if you don't say exhibit and not filed, so automatically say there is a the Act has kept given him some options like if you have to take the permissions from the office, that's like then you can apply, or what other procedure you have to just like take permission and apply, or if it is a with a specific time frame they have specified, within that time frame you have to come come to the office and apply. Okay, so this is the clauses applicable for exhibitions. Similarly, another clause is there, just like say if you consider with reference to defense related, this is also applicable for patents also. I have not explained that component like atomic energy related invention and defense related invention. Similarly, here they have a clause, just like say somebody have somebody, let's say somebody have let's say design a car for military vehicles or also gun that have applications in defense. In that case, that the office has a procedure, they have to take clearance from Ministry of Defense. Okay. So why that type of thing? So that they are telling that the defense part they want to put on in the purview of say Ministry of Defense or part specifically. So somebody want to register, let's say a command or car carrying the commands or gun, that may not be allowed to register without the permissions or from the Ministry of Defense. Okay. So just like say Army board can register the car designed by Army people, there is no problem because Ministry of Defense, if they created some equipment for defense purposes, they can register for that. But others persons, if you want to register, then they have, then office have to take the clearance from the defense, only then it can be registered. So this is the another two important parameters I have not told when I discuss about the industrial design part. So let's for the reason I just in the beginning of this class I referred that component. So now you got the I think most of the components of industrial design we have covered. So now so in this class specifically I will say will deal with the comparative part, comparative aspects of the four forms of IP. Why I have four forms, although three forms. The utility patents I have also put it out. Also, this is a patents definitely, just like US, they give patents for utility part component, they give patent for design components, and they give patents for plant patent. They call it plant patents. So that that's the part. So in this class I have again for revision or recapitulations of earlier thought, I kept this class as a comparative components for others for component whatever we have discussed till earlier class. Okay. So now let's, with a simplified way, we will try to explain the different components. See, I have created, I have taken from the internet or public document site, although it definitely is a protected figures. So a disclaimer for that. So this is only we are using for teaching purposes. Let's say okay. So now see the different types of article I have kept it kept here. Okay. Just like the scissors, this is a painting, this is a spring, this is mobile tower, this is a house, this is also a house. Okay. So now can you able to identify the different forms of IPs associated with those kinds of particle, and how can you distinguish the different components? So within for that purpose I have kept these slides, and this class is also specifically will address those components. Okay. So now if I consider this, let's say mobile tower. Okay. First I am considering the mobile tower. Okay. So mobile tower, the tower itself, if I consider here, we are considering that let's say mobile tower. The name, see, very interesting situation, mobile tower. Okay. So analyzed with reference to definition design. So definitely will ask me that what are the, whether any design features involved there. Design features means not like that design specifically for some functionality, just like this. Design with reference to aesthetic features. Definitely no. So, if no aesthetic features is available here, then definitely you may consider that this will not come within the purview of industrial design. But say the tower have been this tower even another proposition, that if the functional features is solely functional and that functional features also give some sort of aesthetic features, and you can distinguish the functional feature from aesthetic features, then it may qualify for industrial design registration. So, can you able to identify some features that is also providing some aesthetic look, and you can able to distinguish the aesthetic features of that component from that functional features of that components, then it will definitely will qualify for industrial design registration. Okay. So, got it. So, but so in this article definitely patents involved with reference to those functionality. You may consider utility model or utility patents may be there, just like say you are simply changing this components or size of those components that is improving some sorts of efficacy or functionality of this tower, though definitely that may not be sufficient lift with reference to that knowledge of ordinary people. So, then that may qualify for say utility model protection. So, in this article you are getting patent, you are getting utility patent maybe, and say then industrial designs you have to say really test really searched out of that. Okay. But I am telling you that India peoples are trying to register this within the purview of industrial design. Okay. Okay. So, that this way that if this shape and configuration giving some aesthetic look, then only can be available for industrial design protection, but utility patents or patent there is no problem. The functionality components as involved the functionality component within the within this article. Okay. Now, copyright I will say no, but in respect of industrial designs also one issue is coming up that the tower, whether the tower is made and sold independently, and I already referred whether it is physically transferable. So, for that reason the word itself is suggesting the mobile tower. Okay. No problem, mobile means it is say mobile, it can be transferable from one place to another place. So, that way there is no problem for this component to be qualify the definition of article. Okay. So, what you are getting in the mobile itself, mobile tower itself, that we are getting that okay, maybe patents, lost several patents, utility patents for the functional features, maybe industrial design as it is qualifying the definition of the article, there is no problem for it to qualify the definition of the article. Okay. Then copyright, no. What copyright features involved in this mobile towers? Okay. Whether it is a literary work or it is an artistic work. You may consider some aspect artistics, but again I forgot to mention, if something artistics that part will not come within the purview of industrial design. So, there is the say separate features is created industrial design for something is artistic. So, if I ask the why will you differentiate artistic from aesthetic. Okay. So, this is important component, something is artistics, just like sometimes people ask that okay, in a gutka packet you just give some pattern, ornamentation, all those things is artistic or aesthetics. Okay. Sometimes people say those are aesthetic, not artistics, but a painting is artistic. See that this painting is artistic, not aesthetic, but you may consider within the artistic part, the aesthetic part may be embedded, but artistic part reflected more compared to the aesthetic part. Okay. So, that way that within the mobile tower artistic part lacking, there is no per se artistic part within that mobile tower. So, I am not considering this is artistic work within the purview of copyrights. Okay. So, in this mobile tower what we are getting, okay, that patent, utility patents, maybe industrial design, as it is qualifying the definition of the article, no problem. Now, from the mobile tower let us come to this building. Okay. So, building definitely have, now already I have discussed about artistic and aesthetic. Tell me which is remains in this building, artistics or aesthetics, which is prevalent, artistics or aesthetic, aesthetic part. Yeah. So, maybe aesthetic, not artistics. Okay. Maybe artistics are there in few elements, but let us say I am considering this aesthetics. Okay. So, now whether it will be come within the purview of industrial design, the building shape, configuration and ornamentation within ornamentation of this building. Tell me, yeah, shape, configuration, ornamentation if is aesthetic, definitely. So, we are now just like say yes, no format. So, for the this building we are analyzing the different components. So, this is the analysis. So, building, first you are telling that within the design definition aesthetic or aesthetic components by virtue of ornamentation or other part aesthetic. Yeah, if you consider it is yes, then what is the problem for registration of this this building in the form of industrial design IP? Can you guess? Okay. Whether, now question that whether it is article. So, I referred already that industrial design should be applied to an article. So, can you tell whether this is an article or not? Definitely it is not an article. Why? This cannot be physically transferable. So, whatever the article definition, something should be made and sold independently. Okay. So, that way that what you are getting, that this is not an article. Okay. So, you cannot register this the aesthetic look of this building in the form of intellectual property. So, what forms of IP will be applicable out of the discussion now? Can you tell? Yeah, this can be an architectural work, whatever I discussed in the copyright part. Okay. So, if it is not artistics, not an artistics, but it can be qualified as an architectural work. Architectural work suggested that the work should be erected or like this way. So, that way this is a building erected or commissioned in a particular places. So, this is can be qualified easily as an architectural work, no problem. So, it is the mode of protection for this building is copyright. But now come to this building. Whatever I told that for this building 1, now come to building 2, see where the wheels is there. Okay. So, now this building is a portable building. Okay. So, I told this building is aesthetic. So, qualifying the definition of the design, but this is not an article. So, now what people have converted to for getting it to be registered under industrial design form of intellectual property, they have made that building a transferable, means building can be made and sold independently, it should be physically transferred. Means okay, somebody can sell this building, another person can carry or transport that building from one place to another place. So, there is no problem to tell this in the form of an article. Okay. So, portable building can be considered as article. So, there is no problem to register it within the purview of industrial design. Okay. So, portable building can be registered under the purview of industrial design. Okay. So, in this building, that these two part we are analyzing with reference to industrial design and copyright. Okay. This is industrial design, this is copyright. Okay. Then again come back to that mechanical components. Okay. This spring, already I have discussed the spring shape and configuration, mostly technical and functional. You know, spring for specific purpose we are making the spring, including this pitch of the spring, then the coil length and coil strength, all those things for technical purpose. So, okay. So, then may not qualify for industrial design, but spring can qualify for what? Patent or utility model kinds of situation. How the spring can come within the purview of industrial design also means I already referred, again repeating, if you give some surface ornamentation in the spring, that is from providing some aesthetic look to the spring, that enhancing some aesthetic look to the spring, then that aesthetic look will come within the purview of industrial design. Okay. And say that a spring incremental innovation will come within the purview of utility model or utility patent. Okay. So, utility patents, but that surface ornamentation part providing aesthetic look will come within the purview of industrial design. So, even within a functional article, how you are incorporating another form of IP by simply involving that surface ornamentation, you understood. Okay. So, now this article also, let us say, so this article although more functional, how you are involving or creating another form of intellectual property rights within this. Got the idea? Now, this also I told that this is also copyright, but how you are converting this a copyright protected intellectual property and converting from that you are creating another form of intellectual property rights in the form of a mobile house. Okay. So, this is also no problem, portable house, mobile house, I think you may register. Okay. So, now for this painting, beautiful painting as such is, they say, is fully artistic. Okay. So, whether it painting as a whole can be qualified to be an article, no, per se no, but let us say you are incorporating this painting in a textile goods, and by virtue of that, let us say that textile goods aesthetic look have been increasing. In that textile good, incorporating that painting, then it is not artistic, you may consider more, say it is aesthetic. Okay, because eye catchy, beautiful, looking eye appealing. Okay. So, that way this from this painting also you may convert in the form of an industrial design. Then come to this scissors. Okay. This scissors is an useful article, and the scissors functional features can come within the purview of invention either by one means of patent or utility model patent. If it is simply incremental by let us say scissors changing this knob of this feature, by virtue of that you may change that sometime we call pulley arrangement. You changing this part a little bit way different position, by that you may improving a radical improvement, you may get radical improvement in functionality of these scissors. So, definitely the scissors incremental invention will come within the purview of utility model protection or utility patent, and that, but how to involve industrial design features in that scissors itself. sometimes people may give some sorts of ornamental ornamental pattern in the handle itself or handle shape configuration, although giving some sorts of functionality, but also may provide some sorts of aesthetic look. So, by virtue of that, scissors as a whole can qualify for industrial design registrations. Okay. So, that way, that how a functional article where the more functional features are involved, by incorporating some sorts of elements of creativity in the form of a surface ornamentation or in the form of a shape configuration, that is providing technical functional features along with the aesthetic features. By virtue of that, you are providing industrial design features within those articles. Okay. So, now with those article, I try to distinguish your knowledge with reference to these three forms of IP: this copyright, industrial design, and patents. So, patent protect, now you understood patent protect functionality, patent protect invention, industrial design protect creativities, aesthetic features of an article, aesthetic features of a functional article, aesthetic features of an article which can be made and sold independently. Okay. And utility patents, yeah, it also protect invention, it also protect that say incremental invention. Okay. So, that out of those 5 say 3 plus 3 6 object, how in respect of 2 solely copyright, but how that copyright components can be with reference to copyright components, further we can think about that industrial design components also, that part also you came to know. So, so now distinguishing features about that utility patents, industrial design, copyright. There is some intermingle with reference to the copyright and industrial design. I already referred that let us say this painting. Somebody, this painting is there. Now you applied those painting in a carpet. So, now the painting people, the copyright owners of the painting, whether he can enforce his right in the carpet forms, the challenge lies, because now copyright problem is that copyright, the registration is not compulsory, but industrial design registration is compulsory. So, now whether carpet is considered as an article, so industrial design, but you know that they have the very lucid doctrine they have created, that if that industrial design you apply it to a carpet, and if you do not manufacture it more than 50 times and more, then till industrial corporate owners can enforce his rights in that product. Okay. So, these are the things, and further let us say industrial design enforcement also done based on substantial similarity test, just like a copyright. And who will judge the substantial similarity? A person having average consumer who don't just like say person having in just like a for trademark person just like a lay observer test applicable for copyright. Similarly, here also that eyes of the customers, the consumer, who is the who will procuring, it will be judged on the eyes of the customers or customers should be judged by the consumer. This eye appealing to the consumer, you will judge the substantial similarities. Substantiality with reference to the industrial design feature, not the technical features. Okay. So, you got the things. Okay. So, now we are winding up with reference to the industrial design after comparing it with the other forms of IP. Okay. Thank you.